to part two of the presentation, where we're dealing with the concept of significant beneficial ownership. So, again, this is a slightly older amendment, I must point out, and it is something that was brought in initially through the Companies Amendment Act of 2017. It came out of the recommendations of the Company Law Committee of 2016. But if you really were to look for the origin, it is coming out of FATF, Financial Action Task Force, uh, in relation to money laundering and you know corruption, etc. The, the there is a global move across jurisdictions to ensure that complex corporate structures are not used to obscure ownership, and this kind of complicated structure is not used to launder money or um, you know use gains of illicit activities, etc. So the um, move has been to require reporting companies and corporate entities to identify an individual as the ultimate owner of significant stake or shareholding in these companies, so that even if there is a corporate shell or a corporate in front, at least the authorities have a sense of who are the individuals really behind those structures. So this was the core thought behind the significant beneficial ownership. And a lot of this in India is already there in terms of the PMLA Act, the Prevention of Money Laundering Act, and the requirements under that, which apply to financial institutions, etc. And to some extent in the Benami Act as well. But this amendment, Companies Amendment Act 2017, was significant because this was for the first time bringing these concepts into corporate law and company law jurisdiction. So, in terms of the actual amendment itself, there was an amendment to Section 89, which existed, and a substitution of existing Section 90. Subsequently, there were companies' significant beneficial owners rules 2018, which were brought into effect. The SBO rules, and we'll deal with these rules separately. But this was also an important aspect. So, before we sort of jump into what really the amendments were, I think it's useful to just take a minute and talk about what really was the position prior to the amendments. So, some of you may wonder, why do I highlight significant beneficial ownership as a key change in the company law framework in recent times? So, it is not the case that Companies Act has not recognized beneficial ownership. Even under the 1956 Act, there was a clear recognition of the fact that legal ownership could be different from beneficial ownership of shares. So, just to break that down, legal ownership is whose name actually appears in the register of members of a company or whoever the depository, if the shares are in demat form. And the beneficial ownership is the person who actually benefits from the distributions, dividends, or exercises the rights in relation to the company. And so the fact remains that these two could be different people. So if A is the person named in the register of members, when company X gives out dividends on its shares, even though the company will pay the dividend to A could have a separate arrangement with B, whereby the dividends would further be paid on to B. But the sort of default rule in company law has been that whoever's name appears in the register of members, they are deemed to be the legal and beneficial owner of the shares and all rights that attach to those shares. The only exception to this, which was recognized expressly, was if you had made a filing of beneficial ownership with the company. If you'd gone to company X, in this case, the person B has gone to company X and told them that, yes, in your register, the name is of A, but actually the beneficial interest in these shares is held by me, person B. So this was the place where the difference between beneficial and legal ownership was previously recognized in 1956 Act. And this continued into the 2013 Act as well. This was under the earlier Section 89. But what changed since then, and what is the significant beneficial ownership concept? So that was brought in Section 90, which is something that we just get into in a minute. But quickly, maybe it's useful to just take you through what was the definition of beneficial ownership in 89, Section 89, which was brought in by this Amendment Act. So, as I mentioned, even 56 Act recognized the difference between legal and beneficial ownership, but there was really no clear definition or no clarity on what would be legal and beneficial ownership. So, of course, there was a general understanding and developed in terms of jurisprudence and looking at other jurisdictions, etc. But the law itself did not clarify what is a beneficial interest. And Section 89, for the first time through the Amendment Act of 2017, brought in a definition of beneficial ownership. So this is on the screen in front of you. So, I mean, there are some key phrases there, and I think if you take a minute to read through the definition, you will notice that it is quite an open ended definition. So it says that beneficial interest in a share includes directly or indirectly through any contract arrangement or otherwise the right or entitlement of a person alone or together with any other person. 2, subsection 1, exercise or cause to be exercised any or all of the rights attached to such share, or receive or participate in any dividend or distribution in respect of such share. So I think sort of three, four key concepts. One, it is a person who has beneficial ownership, and it is their right or entitlement, which could be directly, indirectly, with one person or a group of persons. And these arrangements could be through contract or otherwise, but the net result is that such person is entitled to exercise or direct the exercise of rights attached to such shares. And by rights, we mean, for example, voting rights or the right to receive dividends or distributions, or the right to receive any kind of distributions in respect of such shares. So, whatever are the key features of ownership of that share actually belongs to this person, and that person is identified as the beneficial ownership. So, moving on, I think this concept of beneficial ownership becomes important because Section 90 brought in the concept of significant beneficial owner. So again, if we can just take a minute to just go through this section 90, the charging section, I think that will help to set the background, the context for the discussion that follows. So section 90, again, is up on the screen, talks about the fact that every individual who acting alone or together or through one or more persons or trust, including a trust and persons resident outside India, holds beneficial interest of not less than 25% or such other percentage as may be prescribed in shares of a company, or the right to exercise or the actual exercising of significant influence or control as defined in clause 27 of section 2, over the company, within brackets hereinafter referred to as significant beneficial owner, shall make a declaration to the company specifying and other particulars in such manner and within such period of acquisition of the beneficial interest or rights and any change thereof as may be prescribed. And the section continues, but this is really the most sort of significant part of it. So again, I'd like to draw your attention to a few key concepts here. First is that a significant beneficial owner is an individual, and I think this is a very important aspect to keep in mind. And what the standard of significant ownership, the threshold at which somebody is defined as a significant beneficial owner, is 25% or such other percent. And just keep this in mind when we come to the discussion on SBO rules. And what does such person do? Any individual who is either holds beneficial ownership, and if you recall a minute ago, we went through the definition of what is a beneficial interest or beneficial ownership, or is able to exercise significant influence or control. Now, these terms itself are separately defined in the Companies Act and other places. So just to give you a brief idea, significant influence is the ability to participate in the operations and decisions, key decisions of the company without actually exercising control. uh, Control in contradistinction is actually being able to appoint majority of directors, being able to hold majority stake in the company, and being able to direct all policy and key operative decisions of the company. So these are sort of varying levels of control that you, or varying levels of influence that a person could exercise in a company. So there could be significant influence or there could be control. And of course, over and above this could be that somebody is 100% owner of the company and exercises full control on this and sole control on the company. So again, coming back to SBO, what SBO refers to is that it requires every company to identify any individual person, a natural person, who either exercises significant influence or control or beneficial interest of 25% or such other percentage as may be prescribed. Now, what so okay, so we've spent some time in understanding what is a significant beneficial owner, but what of this significant beneficial owner? So I think it's important to say a note that there is only a reporting obligation under Section 90 and Section 89 on a significant beneficial owner. So this such person needs to be identified. If there are any changes in his or her ownership in the company, you need to follow that, again, notify the company of such changes. But there is really no other obligation which is cast on a significant beneficial owner. And I think this becomes very important because, especially in the context of companies which are owned by non-residents, there are often some foreign nationals who could be identified as significant beneficial owner. And one of the first questions that comes up almost always is, what does it imply for me to be identified as a significant beneficial owner? So the answer really is that currently the legislation does not contemplate any additional obligations on any person if they are identified as an SBO. This is more for the authorities or the government to know that this is the actual person behind this company. But apart from that, no other obligation. The heart of Section 90 is really that anybody who is a significant beneficial ownership has to declare their ownership to the company, and the company in turn makes filings and reportings to the registrar of companies, and there are prescribed forms for it, etc. Or secondly, that the second limb of this is that the companies themselves have been put under an obligation to file a return of significant beneficial ownership. In other words, one, if you as person A or B holds a significant beneficial ownership in the company, you have to go and tell company X. But that's one limb. The limb two is that company X itself has to ask its shareholders to report their own significant beneficial ownership and to maintain and report a register of significant beneficial ownership. So this really leads us into why this has caused so much discussion and debate. So the very fact that the companies are required to go out there, ask their shareholders to provide disclosure, I think this has caused a lot of definitely discussion, but and to some extent anxiety as well within the corporates and its shareholders. And the challenges on implementation is something that we'll come to as we go forward. But I think that is why perhaps you would have read a lot of discussion, debate, media reports on these aspects. I think the next bit that we should just talk about is what is the consequence of non-identification of SBO. So fair enough, companies are required to identify their significant beneficial owners, a person who is a significant beneficial owner has to give a declaration to the company. But what if this is not done? So there are really two kinds of offenses, or consequences, rather, not offenses, consequences of not following Section 89 right with Section 90. One is that a company which is not able to identify its beneficial owner, significant beneficial owner, either because of information not being properly provided or not being satisfactory, or any person refusing to provide the information, it can apply to the tribunal and ask for restrictions being placed on the transfer of interest in such shares, and or to ensure that the rights on such shares are not exercised. So, as you can imagine, this is a significant chunk of shareholding, anywhere between 25 to 10, 25 percentage or more, and ensuring that the rights on this are not exercised is a fairly severe consequence. I'm not aware of instances where this particular power has been used as of now by the NCLT, but as you can imagine, this is a very high degree, I mean, a high level of restriction that can be placed, and this gives you a sense of how important these provisions are being considered by the government. And this was, like I said, there were two key kind of results. One is what I just mentioned in terms of being able to go to the NCLT and ask for restriction on the exercise of rights on such shares because the SBO has not been identified properly, and this is something that the company in question can do. But apart from this, the section also has three different types of offenses within the section. So, one is for any person who is required to make a declaration not making such declaration appropriately. Second is if the company has received such a declaration and delays or does not meet its own obligations to report the declarations further to the ROC and maintain the registers and filings that it's required to do. And third is an overall offense of any person who gives wrong information or misinformation or fraudulent information. They are separately can be proceeded against under the provisions relating to fraudulent conduct of under the Companies Act. So again, this I just want to highlight is a slightly different striking a slightly different tone here. In the previous part, if you recall, we were talking about decriminalization and how Companies Act is trying to be put into a framework of civil wrongdoing and reduce criminal imprisonment and bring down the consequences leading to better enforcement. But significant beneficial ownership is an area where actually the government has prescribed a fairly high level of reporting, and the consequences of a non-identification are also quite high. So in that sense, on one hand you have decriminalization and ease of doing business and related changes, and on the other hand there is significant beneficial ownership identification, which is fairly complicated and adding to the compliance burden of the company. But again, I think the justification for bringing in further compliance has been that this is motivated by sort of serious concerns around money laundering, illicit gains, and this is part of a global, progression or global move across jurisdictions to identify the individuals behind complex corporate structures. So that's sort of really the context in which I think these provisions have been put for, even though they add to some certain, significantly add to compliance burden. And why is that? I think that is perhaps something that we'll pick up in the next slide. So, as I mentioned earlier, there was the Companies Amendment Act of 2017 brought in changes in Section 89 and Section 90. These were the substantive sections, and this led eventually to the significant beneficial owners rules being enacted. Now, these rules really provide for implementation of the provisions of Section 90. But one very important thing to notice here is that while Section 90 talks about a threshold of 25%, that is, the person should exercise beneficial ownership on 25%. The rules have, in turn, while detailing out the criteria for identifying such person, put the threshold at 10%. which is obviously a much lower threshold, and there has been a lot of debate about whether a rule can bring down the threshold below what is prescribed in the act. So in some ways, the rule is strengthening the or expanding the scope of implementation of the provision itself, and whether that is within the legislative competence. But as things stand today, the threshold under the rules, and therefore the rules read with the act, is at 10%. So there is a specific waterfall identified in the rules, and I'm not going to go into that here, but just want to take a minute to tell you that it's a fairly complex waterfall. So it says, and there's a whole list of presumptions identified. So it says that anybody who holds a majority stake directly in the company, if you exercise voting rights, and these are the simple case forms. Then there are instances where it says that if nobody else has been identified, then any senior managing official would be identified as significant beneficial ownership. And there's a lot of sort of facts which could apply, because clearly this concept is trying to apply to a very wide variety of structures. There are trusts, and there are companies, and there are limited liability partnerships, and these are just the corporate structures which we have in India. And of course, as you would realize, a lot of the ownership, significant beneficial ownership, and the chain of ownership often goes outside India, which has many more types of corporate structures than what we are used to seeing. So, in the attempt to cater to and sort of catch everybody, the rules have been made fairly complicated, and this is sort of one reason why the industry has been struggling a lot with how to implement these rules and how to identify who would be the SBO. And obviously, some specific cases like trusts, investment vehicles, these are areas where it's even more difficult to identify who are the people sitting behind these structures, because in the first place they may be a moving body, or they may not actually be such a person. And in fact, that is one of the interesting things about the reporting requirements. One of the options eventually, after doing the test and going through the waterfall, is that the shareholder can actually say that there is no individual who exercises significant beneficial ownership, and the company then reports that onwards to the ROC. So again, just to give you some idea of the difficulties in implementation, these rules and the actual reporting were, I think, enacted in 2017, but eventually the filings had to be made by December 2019, and I think they were postponed or delayed at least a couple of times, because each time there was a confusion around how to interpret the SBO and who would have to be named, etc. And the other challenge, I think, especially for industries like private equity, etc., was that there are significant confidentiality obligations that these investment vehicles have to their investors, where they are not allowed to, under their investment contract, allowed to disclose the details of who has invested through the vehicle. So the fact that these beneficial ownership laws in India require a specific individual to be named, and if you look at the prescribed form for reporting, you have to give the name of the person, their address, their details, how did they acquire the ownership, what is the percentage stake, how do they hold it, etc. So it's a fair amount of reporting, and there was a lot of concern around confidentiality obligations, being able to give such information, and of course, a general reluctance in giving personal information of foreign nationals as part of reporting requirements in the Indian law. So these are all reasons why, as I mentioned, there's been a lot of debate and eventually delays in implementation. But now this is in effect, and this is an annual compliance that needs to be done by the companies. And once, even after you've made a reporting, you have to continue, it's a continual obligation. So if there are any changes in the percentage you hold, you have to continue to report that. So I think this brings us to the end of part two.